Hello, my name is Cynthia. I'm a board certified immigration attorney here in Houston, Texas. And today we're going to talk about 42B. What is cancellation of removal for non-lawful permanent residents? A little bit about me. I've been licensed since 2018. I have been board certified since 2026. I have practiced immigration law throughout my journey in law. And I practice primarily in family and removal based side. At our firm, we do humanitarian, family, employment, everything within immigration that you can think of. So what is cancellation of removal? So this is something that is very, a lot of people are pursuing this these days, especially given the increase in detentions of many individuals that have lived here for a long time. So 42B, also known as cancellation of removal for non-lawful permanent residents, is part of Section 240A-B of the Immigration and Nationality Act that gives immigration judges the power to cancel removal of certain non-permanent residents who meet specific requirements. So the first requirement is that the individual has to have lived in the U.S. for 10 years. Then they must have family members that are going to suffer extreme and unusual hardship if they weren't allowed to remain in the United States. Now, the beauty of cancellation of removal is that if a judge grants it, then it cancels your removal, hence cancellation of removal, and it gives you a pathway so that you can get your green card, your permanent residency status, and eventually U.S. citizen in the U.S. So the three requirements, like I was mentioning, is that you must have 10 years of continuous physical presence in the U.S. before you can qualify. So everything in immigration in removal proceedings, it starts off with something that's called a notice to appear. Once you are served with this notice to appear, which is the same, you can say kind of like the equivalent of a complaint for criminal law, which basically lays out what the charges that are being brought against you in immigration. So for example, that you've been in the U.S. since July 2nd, 1997, you were not a U.S. citizen, you were a citizen of maybe Guatemala, and you entered the U.S. without documentation. So those are the charges usually. And then the charge of removability, whether or not it's under a provision because you were not admissible or if you are deportable, it'll all be listed on there. So once you are served with that, that stops the 10-year clock. So if when you entered the U.S. 15 years ago and you were served with one of these and you have not technically accumulated any time for purposes of cancellation or removal. So that's very important to keep in mind and understand. You must also show that you have good moral character. That means that if you have specific convictions, even something like a DWI conviction or an assault conviction, things like that, they come into play, which can cause your good moral character to be in question. And then the most difficult part is that you have to show an extremely high burden of hardship that your qualifying family members, which can only be a U.S. citizen spouse or a permanent resident spouse or parent, and children under 21 that are U.S. citizens or permanent resident that would suffer extremely and unusual hardship if you weren't allowed to remain in the U.S. And that is a very difficult burden to meet. I mean, we have many cases that we've had where, we have family members where maybe the dad is the sole income provider, the breadwinner for the family. And, emotionally, we know that the children probably would not be well without their dad. But because there's probably no medical issues or no out of the common educational issues, then a judge may find that that's not extreme and unusual hardship. Usually for this hardship, the judge wants to see someone that cannot fend for themselves here in the U.S. if they weren't allowed to remain. So someone that's maybe, hooked on an oxygen machine, someone that is bound to a bed, someone that is receiving sort of educational help to help them with a educational delay that they may have. It's speech impediment or, whatever it may be. If they have a IEP, individualized education plans, and you can demonstrate to the judge that the educational requests that that your son or your daughter need are not available in the country where the intending immigrant may get deported to, then that's how you can prove that extreme and unusual hardship. And again, back to the stop time rule. So this is a term that we use whenever you are served that notice to appear. So if you have 7 years in the U.S. and then you get issued a notice to appear, and let's say you don't have court for 4 or 5 years, technically those 4 or 5 years do not grant or do not give you the physical presence requirement so that you can qualify for this. So keep that in mind. Sometimes it's not only being served a notice to appear, but if you commit a certain offense, right? If let's say you were in the US for 15 years and the third year that you entered, you committed an aggravated felony, right? Just to be general here, but there's a lot more analysis that goes in there, and you don't get served a notice to appear until 7 or 8 years later, then technically you did not accumulate those 10 years because that crime can stop the physical presence requirement for cancellation of removal. So again, speaking of the hardship, you can't be general when you are requesting this. In fact, we're going to talk about a case that recently came out from the Board of Immigration Appeals that talks a little bit more about what evidence an immigration judge is looking so that you can make a case for cancellation of removal. You can't just say the loss of financial support, emotional pain, but it has to be very specific, right? They need to see a child with serious medical needs. They need to see those medical records, those evaluations or reports from a doctor or a psychologist or a therapist or someone that is working one-on-one with this child or family member, so they can see how severe this medical issue or mental health need may be. They want to see, for example, a spouse. If you're using your spouse or your parent, right, then they want to see that paperwork of what is that disability or what is that medical need that requires for you to be here, right? Not just, you're going to have to disclose if there's other family members here in the U.S., but why is it specific for you to remain in the U.S.? And you also want to include, right, if you have younger children that are in school and maybe they have specific educational needs, like I mentioned, then they need to continue with that. And maybe that home country doesn't offer that. So you want to document that. Also, just in general, if there is a lot of violence in that country where you may get sent back to, right, you want to submit country conditions that can demonstrate that. And, it doesn't have to just be one family member that suffers a hardship. You can do it combined. If you have several different children, if you care for your children and your mom, you can include all of that and use them all as qualifying relatives and witnesses, but as long as you have the sufficient documentation. So if, let's say, tomorrow you are detained, right? God forbid that would happen, but if tomorrow you were to get detained, you've never been in immigration proceedings, and you have been here for more than 15, 20 years, then you are a perfect candidate, right? Because you have the physical presence. But then after that, we also have to evaluate who are the qualifying relatives. Do you have the family members? Do you have the hardships that would suffer if you were not allowed to remain in the U.S.? So then after you get processed, you're going to receive that notice to appear, and you must go to court and go on to the next steps. Our recommendation is to hire an attorney and that you gather the evidence necessary, because not only are you going to have to prove the hardships, but you also have to prove physical presence. So usually one document per month per year that you've been in the U.S. So you need at least 10 years worth of documentation to prove that. You're going to have to file the Form 42B. It has filing fees that have recently increased. They were $110 and now they're a little bit over $1,000. You have to file that. You have to show proof to the court and then attend your hearings. It's a master calendar hearing, the preliminary hearing, and the individual or the hearing on the merits, which is whenever you set forth your case before a judge, and then the judge makes a decision. If you don't win, then you can always appeal to the Board of Immigration Appeals. And that's the process in a nutshell. So what are other ways that you can prove, right, that you've been in the U.S. for 10 years? So for example, if you've been paying taxes, if you have an ITIN, if you've had children enrolled in school, then you can use all that paperwork, all those records, their ID cards, if you have pay stubs, if you have lease agreements, mortgage statements, all of that. insurance records. If you got any sort of certifications, for example, if you were a barber and you've had to renew your license, all of these are documents that you can use to prove that you have been in the US for those 10 years. And then, there's other documents that you can include to prove your good moral character. So, for example, if you attend a church, you can have members in the pastor or the religious director of that entity or organization write you letters of recommendation, family members, friends that they can attest to your character. So when I was talking about that new Board of Immigration case, it's matter of Pelagio Mendoza, and this came out, and it basically said that a respondent or qualifying relative's testimony about a medical or mental health condition will generally not be sufficient to establish exceptional and extremely unusual hardships, where, for example, report, expert testimony, or medical evidence exists, but could have reasonably been produced, but was not. So what that means is that if you are claiming that your qualifying family member, so if you have a son that has diabetes and you are claiming that they need you here in the US, then you must produce that documentation. Do you have the medical records? Do you have, the special notes from school that say that if he needs to take medicine or activities that the child can't engage in? So all of that must be produced. If not, then a judge can either pretermate your application, which means that they may not allow you to go forward with it, or maybe deny it. And if you don't, or you're not able to produce it, because let's say maybe you are going through a situation where you are a single parent and you don't have a family member that can get those medical records, then you should include documentation to the judge proving why it is that you can't get it. If maybe there's no conservatorship in place or power of attorney for another family member to retrieve those documents. But also this goes back to why you should be planning, right? As much as we don't like to live in fear of panic, right? We are living in a time where if it is imminent, right? At any point you can get detained. So this is another reason for why you should have your documents in order and in place, so that if you were detained and you have to fight a cancellation of removal case, you have everything ready to be able to present a good case before an immigration judge. So it is very important for you to prepare, to not wait until you are detained to start gathering these documents. But if you were to get detained, you can call our office. This is certainly a form of relief which you don't want to pursue alone, because it does require extensive documentation and preparation of all the witnesses, because basically you have to state your entire life before a judge in the form of questions and answers and evidence. So reach out to us if you are considering or you think that you may qualify for this, so that we can help you strategize and help you and defend you and advocate for you before a judge, and also evaluate, right? Evaluate whether or not this is something that could benefit you, whether you have the difficulty or the hardship there to be able to win a case. We have a lot of experience at the firm doing these types of cases. You can reach out to us through several different social media platforms to schedule your consultation, and we would love to meet with you. Thank you for your time.